This is the 14th video in this series. It's a continuation of the custodian-dependent relationship. I consider it the most fascinating application of inalienable rights. But if you're not thoroughly familiar with the preceding videos, I don't recommend attempting this one. Got your mind wide open? Here we go. Let us now examine further the issue of withdrawing support entirely. During gestation, an unborn fetus is receiving oxygen and nourishment from the mother through the umbilical cord. Thus, during this time, the mother is automatically providing care to the fetus. This automatic care continues through the birth process and ends only when the cord is cut or ceases to function naturally. This is the moment when a new individual comes into existence. I think we have no alternative but to recognize that at the moment of birth, the mother is in the process of caring for the infant. She must now continue to provide support, nurse the infant or some equivalent, or she will endanger the life of the infant, and then we would have to say that she is guilty of causing harm and is therefore violating the rights of another individual. Usually, an agreement has already been made with a hospital or midwife to provide birthing and infant care assistance to the new parents. The mother can intermittently relinquish care of the baby to the paid staff until she is ready to take the baby home. Now the question arises, is the father also in the process of providing care to the new infant at the moment of birth? And can he be held at fault if he runs away? I think this has to depend upon the agreement, if any, such as a legal partnership, that exists between the two parents. Parenting is usually recognized as requiring both a mother and a father, so parents usually take for granted that the father's assistance can be counted upon. It is an unspoken agreement. If the father disappears, a decision must be made as to whether the father has caused or will cause harm by withdrawing his support. There can be complicated situations, however, such as when the father is not known, has died, or where the parents have now agreed to remain apart, meaning they are divorced. It would seem best for all if the parents made a legally enforced agreement concerning child rearing prior to the first birth, such as a marriage contract or domestic partnership. Now, if the mother gives birth, then disappears without making arrangements for the baby's care, we can conclude that she has abandoned it. This is a type of harm, since the baby will certainly die without care. If she abandons the baby on someone else's property, such as leaving it on a random doorstep, she may also be found guilty of trespass. The fact of nature that only females can give birth results in the mother being in an inescapable position to violate the rights of her child if she spontaneously withdraws support. How should the law view abandoning an infant? I think we can say that, at minimum, the law should provide temporary protection for the endangered child until someone volunteers a more permanent home. Also, the parents should be jailed separately to prevent them from repeating the act. Now we can ask difficult questions about orphans, such as, are a child's rights violated if his parents are murdered and he is left without support? Yes, but not by the parents. The murderer should be held at fault for 2 murders, plus endangerment of the child. Suppose the parents are killed purely by accident. Here I have to say that the child is simply unfortunate. No crime has been committed, so no one can be held responsible. Suppose the parents take foolish acts or unnecessary risks and end up getting themselves killed. We could say that the parents have essentially abandoned the child and left the law with the task of providing protection, but at the same time they have saved the law the trouble of preventing its reoccurrence. I think we can conclude that it is appropriate for orphanages, adoption agencies, and those who offer foster homes to work closely with police departments and other branches of government. We can also conclude that it is most wise for parents to make advance arrangements with friends and relatives for the care of orphans, should it become necessary. Now I want to talk about even more controversial aspects. I'll start with self-defense, discipline, and abuse. Just because a custodian is taking care of a dependent does not mean that there will never be occasions when the custodian will have to defend himself against the aggressive actions of the dependent, just as he would defend himself against any street mugger. Children have been known to become criminals and initiate force against their own parents. But let us examine a more common case, such as a child acting belligerently and destructively, throwing a temper tantrum. Is the parent within his rights to subdue the child with his superior physical strength, such as by spanking? I have to say yes. After all, the parent must protect himself, his property, and his reputation from damage by the child. Besides, an enraged child rarely will respond to reason. Discipline is a form of retaliation against the force initiated by the dependent. Can we draw a line between discipline and abuse, just as we would draw a line between initiatory and retaliatory force among independent adults? I think so, but it gets complicated. One must take into account the full context of the particular custodian-dependent relationship that exists. When a parent smacks his child across the face for some seemingly innocent act, we must first learn the child's temperament and history before condemning the parent. A quiet word of warning may be sufficient for one child, but another may take heed of only much harsher discipline. Just as neglect that goes too far becomes endangerment, discipline that goes too far becomes abuse. If a parent were to beat, molest, torture, enslave, or ultimately murder his child for a transgression, we would properly judge it to be excessive retaliation and call upon the law to subdue the parent. When a child grows up and moves out, discipline is no longer possible. The parent must thenceforth deal with his child as an independent adult. He must not presume that his child is still dependent, nor attempt to force his child to remain dependent. What about withholding a cure, letting a dependent suffer or die, and euthanasia? Let's take our time with this one. Suppose the dependent, through no fault of the custodian, becomes injured or ill. Suppose a child is born with medical problems, such as an incurable disease, severe mental retardation, missing portions of the brain. Suppose a close relative is involved in an accident and loses limbs, is paralyzed, brain damaged, becomes a vegetable. This individual will never lead a normal life and will probably require numerous and expensive operations and exotic treatments, organ transplants, heroic measures, and perhaps constant life support simply to survive. What is the role of rights in a relationship such as this? Most of us would prefer not to contemplate such tragic occurrences, and indeed it is most distressing to find oneself faced with it. We can only hope that it never happens to us. Let us begin by recalling the applicable principle. While no one has the right to be provided with anything at the expense of others, one's rights can be violated when one is provided with support that results in harm. Now let us assume that the custodian's intentions are good. He wishes to do only what is most proper for his dependent. We can start by establishing a basic view that the custodian ought to take every available opportunity to assist the dependent, short of depleting his own resources to the point where neither of them can survive. For instance, the custodian knows that without treatment the dependent will continue to suffer and perhaps his condition will worsen. If a cure is available and within financial reach, the custodian ought to take advantage of it. If it is outside of his financial reach, then we cannot blame him. It is simply a tragic circumstance. But supposing a treatment is available and he makes no attempt to find out about it. Or worse, supposing he knows of the treatment and could obtain it, but does not. Or worse still, he has the treatment at hand, but deliberately withholds it and even prevents volunteers from providing it. At some point, a line is crossed and a violation occurs, because this is similar to coming across an unconscious accident victim and rather than assisting him or calling for help, deliberately standing guard and preventing anyone else from helping. This is worse than backing out entirely. It is essentially violating his right to accept assistance from someone else. Back to the dependent. If the custodian withholds treatment and prevents assistance from outsiders, then I think we can say that he is forcibly preventing the dependent from temporarily seeking the care from another custodian. Now the exercise becomes more difficult. Suppose the custodian purchases less than the best available treatment. He knows he could afford better with little inconvenience, but he chooses not to. Instead, he leaves the money in his bank account. As it is improper to force another person to reveal his assets and decide for him what he can afford, I think what must be demonstrated is the knowledge the custodian had at the time and his actions. If he did the best he could under the circumstances, then he cannot be blamed, even if the child survives but is crippled. But if he intentionally did less than he could for his dependent and harm resulted, then I think we must hold him at fault. This is perhaps one of the most difficult to judge, for it means that we must weigh the importance of curing the dependent versus saving the money for some other purpose, and decide whether to charge the custodian with endangerment of his dependent for being unwilling to give up other things. Numerous other issues must be considered, such as, for example, how likely was the treatment to be successful? If it failed, then the custodian could lose everything. He might end up with no child and destitute. If he judged that nothing could save the child, why should he not forego the attempt and save his money? Should he be held at fault for taking his own welfare into consideration? Such cases are very difficult to judge. Stop the video and take a breather if you need to, because the next several subjects are likely to be even more distressing. When is it proper to let a dependent die? I think we can safely say that when there is nothing you can do that would save him, then you cannot be blamed for withdrawing your support entirely and allowing nature to take its course, unplugging the respirator, for instance. A more difficult situation is when there is a treatment available, but the chances of its success are marginal and may leave the patient in worse condition than he started, or may be extremely lengthy and unpleasant, or could result in the need for further treatment, the expense of which may be prohibitive. Regardless, permission from government should not be required. The only reason to involve government would be to find out in advance what course of action would be judged a violation under current law, so that it can be avoided. I think we can safely make the assumption that anyone injured or sick and unable to communicate would prefer to be cured, providing a cure is possible. If none is, and only suffering can result from any attempt to save him, then I think it would be safe to conclude that he would rather be left to die or be put out of his misery. It would be a violation of his rights to keep him alive, as this would be against his wishes. The most onerous decision a custodian can make is whether to continue paying for life support until his dependent dies, withdraw support and watch his dependent suffer and die, or authorize a life-terminating procedure such as the injection of a lethal drug. His choice must be determined by what is available, what he can afford, and what he believes the dependent would have preferred. Is it appropriate for a property owners association to play a part in the decision-making process? Perhaps. And perhaps individuals faced with such serious decisions would welcome the guidance of their community. Another controversial issue: forced treatment. Taking a protesting child to have his tonsils out can be a painful experience for everyone involved, but I don't see any violation of rights here. One must assume that the child would prefer a temporary inconvenience to a permanent one as a result of being left untreated. Forcing a dependent to accept treatment can get complicated when we consider that the treatment given could be a result of poor judgment. Doctors are not omniscient, and in circumstances where a professional doctor is unavailable, the custodian must rely upon his own best judgment, perhaps assisted by a knowledgeable neighbor. If deliberate harm was intended, or if it was negligence such as prescribing the wrong medication or improper doses, the perpetrator ought to be held at fault, but I don't think we can blame the custodian for doing the best he could under the circumstances. Another difficult issue arises when we consider the case of a child with a rare blood type who is expected to die unless a suitable blood, organ, or bone marrow donor can be found. After a lengthy but fruitless search, the desperate mother decides to produce a second child in the hopes that it will be a suitable donor. The assumption must be that the second child would, if he were able, consent to be a donor. Medical treatment, or pseudo-medical treatment, performed for religious observances and cultural traditions, such as forced scarring and disfiguring, circumcision of male or female, ear and nose piercing, etc., where no medical reasons exist, I think can be regarded as a violation of rights, as from my observation the patient usually objects loudly and receives no benefit. This is perhaps another area where adhering to the CC&Rs of a property owners association would be appropriate. I'll continue in video number 15.